Hi, I'm Danielle G. Van Ness of DGVE Law, and I'm looking forward to meeting with you soon. I'd like to give you a quick Trust 101 before we meet. This is a trust, and the person who creates it is called the settlor, or the donor, or the grantor, or the trustor. Essentially, this is the or person. And this person creates the trust and puts her stuff into the trust. Stuff here being the technical legal term. And then she says, hey you, I really trust you. So I'd like you to be my trustee, who is only ever called trustee as opposed to the or person. And I want you to hold on to all that stuff that's in my trust. You're not actually going to own it, you'll just hold on to it for me. And then I'm going to put all these rules around how I want my stuff to be used and managed inside my trust, and all of that is for the benefit of my beneficiaries. So basically what we're doing here is we're creating a third-party relationship. There's always somebody else involved here. With the most basic kind of trust, a revocable living trust, you can be the person who creates it, the settlor or the donor or the grantor or the trustor. You can set it up and put your stuff in it while you're living. And you can be the trustee of your trust and hold on to everything that's inside your trust while you're still living and as long as you're able. And you can be the beneficiary of your trust, along with your family or anyone else you'd like while you're living. The key here is that if at some point in time you're not able to continue serving as trustee of your trust, you've already named the person that you trust to be your backup trustee, your successor trustee. And then he or she also has access to hold on to all the stuff that's inside of your trust and follow all of your rules for how you want that stuff managed and get it all to you to take care of you if you're incapacitated but still living. And of course, when you're no longer living, then we have your contingent beneficiaries, the people that you'd like to take after your death. And then it's up to your successor trustee to follow all of your rules to get your stuff to your contingent beneficiaries. The key here always is getting the stuff inside the trust. And that process of putting the stuff into the trust we call trust funding or asset alignment. It sounds very fancy, but really all we mean is retitling your assets so that they're owned by you or someone else as trustee of the trust instead of by you individually. It's really critical that all of the stuff is actually inside the trust, because if we forget about some little bank account or we think it's not worth it, and then there's another small little life insurance policy we forgot to address, and those things are all dangling around outside of the trustee can't reach them. They're not inside the trust, and then we have to deal with those assets in a totally different way, which might involve using a power of attorney or going through the probate and family court. So that is a quick Trust 101, and I hope you find it helpful. I'll see you soon. Thanks.